to everyone. We're going to start the Tuesday meeting of the House Judiciary Committee meeting. We've got several things to take place today as far as hearings, and I believe there was some, let's see, I'm not going to take them exactly in the order we have them here. Haven't had a chance to study this as I came downstairs. Is Mr. Weldon here in our meeting as yet? Not yet. All right. Mr. Lindsay, we got your Medicaid bill already on our calendar. That is about as fast as the moving I've ever seen happen from the court, from the speaker changing committees 10 minutes ago. It's on the calendar.
I like to be a can-do, can-we go?
Well, we'll let the congressman go first then. With that kind of magic power, that's got to be recognized. We're going to look at House Bill 973 to begin with. You can sit with your other presenters, or you can stay in your seat, whatever you prefer.
Thank you, Mr. Chairman. This is a bill being brought to you by both the Department of Community Health and the Attorney General's office. The committee, those of you who were here in 2008 will recall that we passed in 2008 the Medicaid False Claims Act, which has resulted in Georgia being able to recoup literally millions of dollars from individuals and companies that have attempted to defraud the state in regards to Medicaid and Medicare claims. Periodically, in order for us to remain in sync with the federal government, we need to make adjustments to the bill so that we're able to recoup the full percentage that we are permitted under federal law when we work with the feds in terms of going after those individuals who are defrauding us. Basically, what the False Claims Act does, for those of you who weren't here, is it allows a private cause of action by a whistleblower to either work with the by the Georgia Attorney General or on their own with permission of the Attorney General to seek recoupment of false claims. And then a certain percentage of that money goes directly back to the state of Georgia. I have with me today, if y'all could sort of...
Thank you very much, Representative Chairman, members of the board, members of the committee. Thank you for your time today. My name is Lisa Marie Shekel. I am the Legislative Director with the Department of Community Health, and I have with me today the Department of Community Health's Inspector General. And if it is the will of Representative Lindsay and the Chairman, I'd like to turn this over to him so he can speak on more details relative to the recoveries we've experienced as a result of this legislation.
May I ask a question?
Yes, sir.
Ms. Lindsay, is it not true that the purpose of this bill is to bring our Medicaid fraud laws in line with complying with the federal standards that are required now? We passed a law 2 years ago, I believe, dealing with Medicaid fraud, and there are regulations that have come down from the federal government that address some minor tweaking changes that we need to do in our current law.
Yes, sir.
You want to say anything else?
The only thing I want to add, if I will let the Inspector General just very briefly, I think the committee might be interested to know just how much we've been able to recoup.
All right.
That's basically it.
Sure thing. And good afternoon, Mr. Chair and members of the committee. Appreciate you letting me speak before you. We primarily have received a benefit from the False Claims Act. The State False Claims Act passed in 2007 to allow us to have an enhanced share, a 10% enhanced share of recoveries. Since that time, the department estimates that year to date, and that means through state fiscal year to date, we have recovered $11.6 million additional dollars as a result of the enhancement that the State False Claims Act, being aligned with the Federal False Claims Act, has allowed us to do.
Outstanding.
That's essential. Basically, if we had a fiscal note, we'd be in the black.
That's right. Thank you. Anything further you want to add, Ms. Lindsay?
That's
Any questions by members of the committee of the presenters? We have one, I believe, over here.
Hello.
Yes, ma'am.
Thank you, Chair.
Ms. Jones.
11.6 million from whom, over what time period, and what for specifically?
These recoveries are associated with actions brought under either the state or the Federal False Claims Act. The timeframes that I'm giving you are specific to state fiscal years 2011 through state fiscal year 2014 year to date, so as of literally yesterday. That's based on an estimate of what we got, because we are entitled and have been entitled during that time frame to the enhanced recovery, based on the fact that we have received a large number of global settlements. These are typically actions brought on a national basis, dealt with through the National Medicaid Fraud Control Units, through our Attorney General's office and the Medicaid Fraud Control Unit there, that have resulted in total dollars recovered of $52.242 million. Those are state funds in that time frame returned as a result of those federal false claims actions. And of that, we estimate that the enhanced benefit that we have seen, because we have a State False Claims Act that is approved through HHS-OIG, that we've received an additional 11.6. So it would be 11.6 as a part of that 52.2 total.
Yeah. The total we've covered is $52 million, but because we're in line with the feds, we get another 11 million of that was an added bump that we get.
And how much of that were fines, and how much of that was the money actually lost or fraudulently taken from the Medicaid?
The way it works is that the False Claims Act, it's maybe a little bit difficult, maybe you can break it down to discern, because part of it is when someone is found to be in violation, there are a certain number of penalties, but there are also treble damages involved.
That's correct. There are treble damages, up to treble damages associated with each individual action, and a fine per claim submitted. And as you might imagine, when we're talking about the size and scope that we deal with in Georgia Medicaid, that's a tremendous number of actual claims. So that 52.2 million represents the state share. In other words, a percentage of the total, because we have to pay the federal share back. This is not the federal share. And so it would be the base amount that was identified as being false claims, plus any penalties associated with it in terms of the treble damages modifier and the per claims count. Those tend to be worked out as a matter of negotiation through council on a national level.
Any further questions of members of the committee? If not, do we have anyone else who would like to address the committee on House Bill 973? If not, the chair will close off further public input, and the bill is now in the breast of the committee. Any discussion on the bill by members of the committee? If not, the chair will entertain motion. Have motion do pass. It's been seconded. Any discussion on the motion? Any amendments?
Yes.
We do have an amendment.
The amendment, in order for us to stay in full compliance, we need to have it to go into effect upon the signature of the governor.
All right. Do you want to have that presented as your amendment, Mr. Lindsay?
Yes, sir, if you would. Thank you.
Thank you. We have one amendment submitted by Mr. Lindsay as AM 370227. Does everyone have a copy of that? Any questions, discussion on the amendment? We have a motion and a second on it, correct? Did I miss it? Okay, second. Any discussion? If not, we'll call for the motion on the amendment, which is due pass. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carried. Nay? All right, one nay. We're back to the main motion, which is the motion on 973 as a due pass, now as amended with a committee substitute. Any discussion on that motion? There being none, the chair will call the question. The main question is due pass. All in favor signify by saying aye.
Aye.
Opposed, like sign. One nay. Chair rules the matter passes by voice vote. Thank you.
Thank you, Mr. Chairman.
Mr. Wells is not here yet, so I'm going to go ahead and proceed on House Bill 643. And although I'm the author of the bill, I've had Mr. Lindsay chair a special committee that was appointed, made up of members of this committee and one other person who's a lawyer in the House, to review the bill and come forward with a proposal. And I would ask, if you could, Mr. Lindsay, to give us a report of your special committee, please. Let me get, which mic is yours?
I don't have a number.
There you are. 15.
Thank you, Mr. Chairman. The subcommittee, the special formed subcommittee dealing with e-discovery did meet regarding HB 643 and worked on several different proposals from the original version, and did pass the bill out under a due pass recommendation to the full committee. And would the chairman like me to sort of go through the bill?
Yes, sir. I think we need to probably enlighten all the committee members from the first proposal. It said the one that we had that you started with was LC 2950 775. Is that right? And then you're now working on what will be the proposed substitute, which is LC 295905 ERS. Is that correct?
That's correct, Your
All right.
Mr. Chairman. Going through the substantive parts of the bill, moving down through lines 25 through 29 of the bill, we did, you will see that we struck certain portion, and we added the issue of proportionality in terms of the discovery request. Basically added the language of and proportional to the needs of the case, considering the factors identified in paragraph 2 of this subsection. Let me sort of back up and say, Mr. Chairman, to the extent and where we could, we attempted to mold this bill to the federal rules regarding various discovery issues. The goal is for a party in the state of Georgia, regardless of whether they are in state court or federal court, would understand that the rules of the road would be essentially the same. This is especially important for folks who are not yet in litigation, but do face the possibility of litigation, allowing them to know exactly, be able to research and know exactly what their obligations are regarding storing and maintaining of discovery. With that in mind,
What do we gain? I'm sorry, go ahead.
Yes, sir.
I think we might take, as a suggestion, if you're open to it, take changes as you discuss them, and then have among the committee members any issues or questions they want to present to you about it.
That'd be fine. We've already discussed the first part regarding proportionality. The second major part begins at line 35. With the major change being a balancing test in terms of the burden, the cost burden involved, and we basically pulled the language from the federal rules. And Jill, if you could help me out wherever I skip something over, just let me know. Where we've added the language which is in compliance with what's in the federal rules, the burden or expense of the proposed discovery outweighs its likely benefit, considering the needs of the case, the amount of controversy, the parties' resources, and the importance of the issues at stake in the litigation, and the importance of the discovery in resolving the issues. Once again, we're attempting to bring some common sense to the discovery process to make sure that we don't attempt to shoot a fly with a shotgun, for want of a better term. But we are making sure that discovery remains proportionate to the issues involved in a particular case.
Questions of members of the committee about that particular section down, what really reads down through line 51 as far as
Yes, sir.
provisions of the substitute bill?
Yes, sir.
May I ask a question? I'm wondering, what do we use as the standards in trying to have the court, assume the court be the one doing this, apply the question of whether or not it outweighs a likely benefit?
Well, I think that's going to be dependent upon each case, Mr. Chairman, and that's why we've left it to the discretion of the judge to a certain degree. Well, first off, we would expect the parties, obviously, to try to work that out between themselves amicably. But in the end, that's a very fact-based question that I believe is going to be different in different cases.
Is that a part of what the federal standard is?
Yes, sir.
So the question of whether it outweighs and is likely benefit is one that the courts consider with.
Courts could take into account, Georgia state courts could take into account federal decisions along those lines. Yes, sir.
All right. I think we got another question on that point. Who's number 12? Mr. Welch.
Yes, Mr. Chairman. Representative Lindsay, the question I have is dealing with the language of proportional to the needs of the case, considering the factors identified in paragraph 2. How do we determine what is proportional to discovery and obtain the information that's sought?
I'm not sure if I understand your question, but basically that's going to be an issue in each case in terms of perhaps if you could explain your question a bit more.
Well, the way I read the application of subparagraph 1, the standard which you're creating is a proportional to the needs of the case standard in paragraph 1, which then would be applicable to all of the subparts under 2A.
Yes, sir.
And so in my reading of 1, 2, and 3, Roman numeral 1, 2, and 3, each of those seem to me a kind of a yes or no question as opposed to a balancing. And the way I understand it, proportional to the needs of the case is a weighing factor. It's a weighing that the court would have to do with respect to each one of the 4 subparts. And my question is, how would the court weigh whether a person has had ample opportunity to seek discovery?
Well, I do believe that proportionality could be applicable to all 4 of the issues involved. In some situations, proportionality will deal with costs. In some situations, it will deal with the manpower needed in order to comply. Where would be the best place to place the burden? For instance, where there is a opportunity to where there's duplicative discovery involved, that's more of a manpower, but proportionality I think would apply there. When it comes to whether or not it could be provided from another source, I think proportionality would be applicable there as well, as well as 3. Obviously, I think under 4 would be the one in which it would be most applicable, but I believe it could also be applied as a test in the other ones as well. Sometimes proportionality will take on the issue of expense, and sometimes it will take on the issue of manpower, and which party or which method will be the least burdensome in order to obtain the discovery needed in order to prosecute or defend the case.
Have we seen in terms of decisions, and I just don't know, but have we seen the application of a balancing test, a proportional balancing test with respect to the items 1, 2, and 3?
I don't believe it generally comes into play in those, no. I think it more often comes into play in the 4, to be perfectly candid.
Nothing further.
Thank you. Is Evans, that you?
Thank you, Mr. Chairman. Representative Lindsay, I just wanted to get some clarification and make sure that we're all on the same page. Do you agree with me that the language in the substitute at lines 28 and 29 about proportionality, that is language that we are adding to Georgia law, but is not language that appears in the federal rules? And in fact, the federal rules, what it says under the scope of discovery, at the very end it has a statement that says all discovery shall be subject to the limitations set forth in, I believe the subsection is 26B2B, which would be our equivalent of lines 40 through 48. Is that true?
I do believe that that's correct, but I believe that the issue is properly in that place. the state bar weighed this issue carefully and is included in their recommendations to us.
Has the state bar taken a position that they believe that proportionality should be in lines 28 and 29 in the
Position taken
scope?
it was a committee created by the state bar that first proposed the language to us. I don't believe that the executive committee of the state bar has taken any position on the bill.
They have not.
Thank you.
They have not.
But this was a bill that was brought to us, which contained members of the bar on both sides of the issue that helped draft the original one.
All right, go ahead, please, Mr. Lindsay.
Thank you, Mr. Chairman. The next area where there is a substantive change is contained in at lines 114. Jill, can you help me out here in terms of the substance of the change? Oh, we're dealing with basically where language is being withheld, whether with discovery is being withheld, and the obligations of the party asserting particular privileges, and what type of documents will be withheld, and when you raise the defense of regarding confidentiality, as opposed to attorney work product or trial prep material, we have listed certain obligations that the party asserting that will have to set forth, including a privilege log that will be required and the contents of that privilege log. There will be an amendment, and I will be bringing it that some folks did want us to be considering regarding this, and I will have that amendment at the appropriate time. But basically, this sort of sets out the obligations in regard to a party that does raise that defense. It also makes it very clear that if someone has inadvertently turned over privileged documents, the method by which they are to raise that issue, that they have inadvertently done so. We've required that they do so promptly upon discovery of the inadvertent release of privileged documents, and also set forth the duties of the party that has received a document that is otherwise privileged, the requirements of that party in terms of either destroying the document, returning the document, or if they disagree with the assertion of privilege, holding it without further distribution until being ruled upon by the court.
All right, that's all under paragraph A.
Yes, sir.
Subparagraph A.
Yes,
Any
sir.
questions by members of the committee of Mr. Lindsay on this area? This is on lines 114 through 134.
It actually goes to 151. It's that whole.
I'm talking about paragraph A right now.
Yeah.
But he's
Paragraph B. Was he?
speaking of all of it.
I spoke to all of it.
Did you? Okay. Excuse me. Stand corrected. Miss Travis.
Mm-hmm.
Keeping all on the same page. You also added work product. That was something you did.
Yeah.
Questions by any members of the committee? I see none. Proceed, sir.
The next area where we that we looked at and we made changes deals with protective orders. Jill, help me out here.
You didn't make the language that's on page 6 is the same as been traveling with the bill for quite some time. There haven't been any changes here. To my memory.
The next area where we made substantial changes deals with the voluntary or court-ordered meetings, lines 216. There was a lot of debate on this particular issue, whether or not that meeting should be mandatory in all cases, whether it should be whether it could be mandated by the assertion of one party, or whether or not it could only be mandated if both parties agree, or whether or not it should be followed only if both parties agree. The subcommittee reached the conclusion that it should be in place only where both parties are in agreement or upon order of the court. The feeling is that the vast majority of cases filed in the state courts in Georgia will not require this kind of complex discovery meeting and scheduling order, so that but there are some cases in which it will. And so in those cases where there is more complexity involved, the parties can either mutually agree or the court can order. That's where we finally came down on that issue.
Any questions? Let me pose a question. What happens if you have one party saying, I think it's beneficial for us to have a meeting, the other party saying, I don't care, I don't want to have a meeting? So you have two lawyers who are opposed the position to take on it. Can you file a motion to
Yes,
ask the court?
Yes, sir.
And that's spelled out?
Yes, sir. It's up to the court has the discretion in order to order it.
Any questions from members of the committee on the area that we're talking about as far as section F beginning at 216? Looking over on line 271, we have again a recognition the court. This is really starting 270. The court may also address other matters, including the issuance of a protective order and, when necessary, an allocation of discovery costs for the proper management of discovery and action. What was your subcommittee's thinking in inserting that language?
Basically, the decision was that if the court does order a discovery plan be put into place, it allows the court the necessary leverage in order to make sure that that plan is being followed, including the allocation of costs to a party who's refusing to cooperate.
Will there be sufficient information in order to make that determination by the court at that juncture?
Well, like I said, it's going to be very fact-intensive in terms of each case. It may very well be a situation, and I've often seen this, in which courts will defer a ruling on costs until a later date.
Ms. Evans?
Thank you. Thank you, Mr. Chairman. Your response to that question prompts a question from me. I have a proposed amendment later to deal with what I had viewed as a problem with whether we're going to allocate all of a party's discovery costs, including their attorney's fees, as separate from what I usually think of as discovery costs being the hard costs of producing and copying, things like that. But your answer makes me think that what we're really aiming to do here is it really to allocate the cost of the burden of having to go to the court and ask for this meeting versus actual discovery costs. So those are two different things.
I would say that depending on the court's discretion, it may very well be both.
Okay.
Shouldn't we be giving the court that kind of discretion?
Well, at this stage, I share the chairman's concern. I'm wondering what would actually be before the court. But whatever it is, if it is true cost of discovery, are your feelings that it should include attorney's fees, or just simply the hard cost of discovery? And by hard costs, I mean paper, electronic discovery costs, things like that.
At this point, in this particular section, only deals with the cost of the discovery itself.
The paper.
Yeah.
Okay. Thank you.
And that'll take us through the end of section 1, correct?
Yes.
All right.
The next substantive changes took place on section 3, which dealt with the option to produce business or personal records. We added, first off, we added the language regarding personal records as well as business records to make it very clear that we're talking about any kind of records, regardless of the nature of the party involved. We also are requiring, rather than, you ask a specific question, what was the, what was the train carrying in, on the day of the accident. Instead of, and all of a sudden in return of that you get a document dump in which you get documents this high, and basically it's somewhere in these documents. Good luck, you go find it. In those situations, we felt it was reasonable for the party who is responding to a interrogatory request in particular, with a turning over of documents, and there be some kind of specificity in regards to where exactly the documents are that will help answer those particular questions.
All right. Any questions regarding Section 3? I see none. But we do have, I'm sorry. You have a question?
Thank you, Mr. Chairman. Lines 303 to 305, is that totally new?
Yes, that's dealing with our
Paper and electronic documents, though. And there's nothing in our case law that, or statutes that requires that now. Is that
we're trying to return civil back to the practice.
and typically is that language included in other states or in the federal law?
I believe this is language that will be considered, and yes, I don't believe it's in federal, but it is.
Not in the federal rule today, but you think it is being considered or has been enacted in other states. This is a new burden. If I give 3 years of tax, 3 years of bank statements, or if I subpoena the bank to give me 3 years of bank statements, does this ask the bank to pull out those items in the bank statement that relates to particular gifts that are given to a party? In other words, can I ask them to analyze the bank records for me?
I don't believe that you can have them analyze it without tell them that to a non-party. No, I don't believe that was part of it.
To a party, then.
To a party, I think that there would have to be some degree of specificity. If you have knowledge of where the particular information is, you would be required to tell them.
Give me 3 years of bank records, and I'd like to produce those records and to specify where in the bank records all gifts were purchased that exceed $100. I could do that.
I believe that you would be within your rights as in your response to say that particular bank records involved with to supply that information. So situation I would be that we're dealing with the more abusive situation when there's someone who simply just comes up with random different kinds of documents. Because somewhere among these various different kinds of documents.
I think this is an interesting new opportunity for me as a litigant to say to the bank, and I'll just use that as an example, I want 3 years of bank records, and I want you to highlight every time you wrote a check to Riches.
They wouldn't have knowledge of that, though.
The check would say to Riches.
Well, to Rich's where I was saying the payor.
I'm just thinking, is that what you intend to give me that right?
I don't believe that would be required.
Okay.
I think that what would be required is that the bank say that, here
If
are
it's-
particular bank records from these 3 years, and here are the particular checks, and the applicable information within a certain time frame. I think that would be
Following up on that, is it also pretty much recognized if it's something that's easily ascertainable by the party asking for it, as it is the one who's providing it, it's not something you have to provide any more than they have the opportunity to go and find it themselves. If you're having to search through it to find it for them, per se, it's different where they have knowledge. It's in that particular sheet of paper that we put in the pile that's half a foot high.
Let me give you an example of something that I often do. I do the animal of insurance defense. And the animal of insurance defense often deals with various policy issues as to what may or may not be covered. And I'm often asked, what are the policy limits and what are this and what are that. I'll be honest with you, given the fact that there may be questions down the road of what is and is not covered, I often provide the policies themselves, rather than try to interpret the policies information that he asked for, but I'm also making sure that, and I am giving him the particular policy that's going to provide him with all that information. I think that would be sufficient underneath this rule.
I think you're, and in my practice, I'm looking for checks made to certain
Number
people.
12.
I'm sorry, Mr. Chairman, did I
No,
want
I'm
to?
sorry. Go ahead, please.
I'm just thinking really as a practical matter in my
Yeah.
practice. This gives me some interesting new opportunities over and above how I use discovery now. But is that the policy decision?
I think, to a certain degree, yes. It basically will hopefully cut down on the more abusive situation. What we're trying to do is cut down on the more abusive situation.
And not add to.
Yes, sir. Yes, ma'am.
Thank you.
We're trying to like I said, we're trying to return the word civil to civil practice.
Mr. Welch, you have a question?
Yes, thank you, Mr. Chairman. Would line 303, would that now allow me to respond back to a request for documents? Could I now respond back saying, well, could you be more specific in the documents you're requesting?
Well, keep in mind, this is in a slightly different situation. This is a situation in which this isn't dealing with the request for the documents. This is dealing with you responding to an interrogatory question by producing documents. For instance, getting back to my analogy, when sometimes I'm asked for certain explanation of insurance that's applicable in a particular case. Instead of my general practice has recently been over the last 10, 20 years is to simply turn over the policy itself. So we're not dealing with the production of documents. We're dealing with turning over documents in response to an interrogatory request.
Okay, and the way I was reading this, that the responding party may answer by, and then I guess I'm asking, may I respond as the person that has interrogatories propounded to my client? May I respond back by saying, I object, request that you be more specific in the documents that you're requesting?
Well, once again, this is an interrogatory request, not dealing with not a production of document request. So I'm totally lost.
Okay, or identified. But I'm asking, can I respond back saying, could you be more specific in the documents you want me to identify?
Yes.
Okay.
All right. Anything further on Section 3? Being none, we'll proceed to the next section, or next area.
The next area that I believe that we had the most discussion is dealing with the application to non-parties, and we'll get a particular amendment regarding that at the appropriate time.
It's under Section 4, Paragraph C.
Yes, sir. Beginning of 358.
That begins on line 358. All right.
I don't think there's anything terribly changed from the original bill there. The next big change would be on line, rather page 16, and this is where there's likely to be the most discussion. One of the two areas where there's likely to be the most discussion. What we have been confronted with here is what to do with the failure to preserve electronically stored information. The Bar Committee recommended that we go with a proposed new federal rule on this particular issue. There was also discussion on us attempting to craft a wholly different state rule. What the subcommittee sought to do was to take the existing federal rule dealing with electronically stored information, and then simply add the various sanctions that you can also seek in federal court. The goal being for us to have a rule that was as best as we could in sync with the existing federal rules and with the existing sanctions that you could find under the federal rules. With the hope that we could then turn to our state courts could then look to the 11th Circuit for guidance, and so that we could have some consistency regardless of whether or not we're in state or federal court.
Would you direct us to the language that you're speaking of as far as the federal rule language?
Federal rule language can be found by and large at lines 530, beginning at 534, dealing with the use of the exceptional circumstances. We then, once we look at that, we recognize that we did not have in our state law the various sanctions that could be imposed, and so we attempted to craft, tracking as best we could, the federal rules, the various sanctions that could be offered, where where exceptional circumstances were found and where exceptional circumstances were not found, in terms of the various different remedies that the court could either offer or sanctions that they could impose.
Thank you. Let me ask you a question. I'm going back to line 533, and this is the title section of the paragraph C, and it's failure to preserve electronically stored information. Are we dealing only with the failure to preserve that information, or is it the failure to preserve anything that may be discoverable information? Or do we have a separate section dealing with that?
Jill?
I think it's only electronically stored, but I see the catch line at line 533 is what we've been using, but I see the difference
I'm
in
questioning that.
lines 534 and 544. We say preserve discoverable information as opposed
I think we
to
might want to look at
electronically
changing
stored.
that as a title, because that would, I think, could be confusing to parties as well as the court.
Yeah, I think perhaps the better way, regardless of whether it's electronically stored or otherwise, I think the rule should essentially be the same.
Yeah, what I see added on line 535, I mean, take up the conversation with it. Then we have the same wording we had down to conduct of litigation, comma, absent exceptional circumstances. That phrase is added in to what was the prior language that we had, and
Yes,
then it
sir.
reads the rest of the way. What was he thinking of?
That language comes directly from the federal rules.
The current federal rule?
Yes, sir.
Okay. And that's something that recognizes by exceptional circumstances the computer blew up or other things happen.
Exceptional circumstances would be probably more in line with if there was some type of deliberate attempts to destroy documents. or hide
Okay.
documents.
I'm reading the failure to preserve or provide must be done unless exceptional circumstances, and I guess I'm not sure. You're reading it a way that's saying, okay, they did something to destroy it. I'm thinking exceptional circumstances is something happening beyond my control. I'm not sure if that's clear to me or to others, but I wonder how the courts have interpreted that.
Basically, differently than you stated, Mr. Chairman. Basically, the absent exceptional circumstances deals with the possible misconduct of the party who is supposed to be preserving the documents.
All right, we have a question from Ms. Evans again.
Thank you, Mr. Chairman. Representative Lindsay, can you tell me the difference between the reference to exceptional circumstances on 535, line 535, and then on 546? And let me give a little bit of context.
Yeah.
It seems like to me that we're saying in lines 544 through 556 that even though a party has failed to preserve evidence that was not the result of a routine document preservation system like we're talking about in subsection C1, then unless there are still exceptional circumstances, I think in a bad way, there can be no penalty for that. And I don't know that that was really the intent, and that's why I'm asking the question. Should we have the exceptional circumstances?
Well, keep in mind that there are remedies available, ABC lines 539 through 543, even with the absence of exceptional circumstances. there are remedies the court can impose.
But so the intent would be that for the remedies in lines 547 through 556, that those only be imposed if there is a quote-unquote exceptional circumstance.
As it's presently written, yes.
And that language comes from where?
That language is an attempt to balance, to take the existing federal rules and to also impose the various sanctions that we found in the federal rules to different circumstances. Jill, you want to sort of also help me with that?
Well, the problem is the federal rule is 91137E. It's one short paragraph, but it brings in, it says the sanctions provided by this code section, which are a whole lot of other sanctions, and we don't have those spelled out. So we had to import that idea into this subsection to fully flesh out the flavor of the federal rules. So this was the effort that was made to, does seem to be in the federal rules a distinction between exceptional circumstances and more run-of-the-mill, and so that was kind of the idea behind the division in paragraph 1 versus paragraph 2.
But are the exceptional circumstances that we consider in the federal rules, isn't that really where we're saying if it's a routine destruction because you have a document retention policy that says you clear out your email once a month or once a year, we're not going to punish you for that producing party unless there's an exceptional circumstance. That's really the only time that the exceptional circumstance language is used in the federal rules, and so I'm worried that we're adding more conditions, and I want to make sure I'm right.
I'm not sure where we're adding more conditions. I understand your question because we did try to divide out. We tried to look at the federal rule and say, okay, even in the absence of exceptional circumstances, the court has within its discretion and should have within its discretion the ability to seek remedies to assist the party to do the discovery that it needs to do in order to prosecute or defend its case. And that's what we lay out in A, B, and C. And then we looked at the various sanctions that the courts could impose, and given the language contained in Federal Rule E, in which it says that only with exceptional circumstances should sanctions be imposed, we then listed all the possible sanctions that were contained in the federal rules.
But am I right that the federal rules don't impose that exceptional circumstances condition on the sanctions that are listed in 547 through 556?
I would disagree with you there.
Why?
Because what I would say is that the E underneath the federal rules makes it very clear that you're not supposed to impose sanctions absent exceptional circumstances.
But only in the case, but that's the opposite use of exceptional circumstances, I think, because it says if you've destroyed something because of your routine document destruction policies, we're not going to punish you unless there are exceptional circumstances. It's not we're not going to punish you for anything unless there's an exceptional circumstance. Those are two different uses of the phrase.
I'm not following you, and I apologize. I believe that the existing E basically will only allow the added sanctions where there exist exceptional circumstances.
I think we just have a disagreement on the reading of the federal rule.
We may very well.
Mr. Welch.
Thank you, Mr. Chairman. Representative Lindsay, the way I'm understanding the change on lines 533 through 556 is that the federal rule says that the courts will not impose sanctions unless there's exceptional circumstances that exist. And what you've done is you've actually created an opportunity where if there are no exceptional circumstances, but there's been some failure to preserve, you're creating an avenue for some sanctions to be put in place.
Some avenues for relief. Yeah.
Okay.
We want to call them sanctions or avenues for relief. We are basically setting out, and these are also in the federal rules. We are setting out the remedies that the court can come up with in order to allow a party to continue with its discovery and be able to either defend or prosecute its case. Yes.
And under the federal rules, the remedies that you have A, B, and C on lines 539, 540, 541 are not available to someone that where there has been a failure to preserve electronically stored information. Under the federal rules, right now, you wouldn't have these remedies unless you can prove those exceptional circumstances.
No, I would disagree. I think A, B, and C, under one A, B, and C, are available. If you look at the totality of the surrounding federal rules, I believe if you look at the totality, these are remedies that the court can impose, even in the absence of exceptional circumstances.
Okay, because I was reading the federal rule E here says failure to provide electronically stored information. It says absent exceptional circumstances, a court may not impose sanctions under these rules on a party for failing to provide electronically stored information, loss as a result of the routine good faith operation of electronic information. So I was understanding that you're actually giving us a little bit more in terms of remedies than we would.
Well, there are remedies and then there are sanctions.
Okay.
And perhaps, let me be more clear. Perhaps I'm not sure, maybe I wasn't as clear as I should have been earlier. There are remedies and there are sanctions. Remedies are basically avenues that the court will allow you to go down, additional avenues that you should be allowed to go down if these documents, for instance, are no longer in existence, in order to be able to come up with the information that you should be entitled to if they had been in existence. The sanctions are there when there are exceptional circumstances.
Okay, and then am I understanding you correctly that the intent of the language from 533 through 556 is to create I'll wait while he reads.
All right. Here's a question I've got too, Ms. Lindsay. Look at the former language we have under the 5775 bill. This first paragraph, number 1, reads, if a party fails to preserve discoverable information that reasonably should be preserved in the anticipation or conduct of litigation, the court may provide one of the following. We start out with that same language in this paragraph 1, but then we shift it to speaking only as to the electronic information. And I guess my concern is there we have taken what starts out to be the full meaning of failure to preserve discoverable information, and we've narrowed it down to failing to preserve electronically stored information.
I think, as the chairman pointed out earlier, at the appropriate time, it would be better to, it would be advisable to do a tweak there and apply it to all documents.
All right. Any further discussion among members of the committee regarding paragraph C?
Well, Mr. Chairman, that was I'm sorry, I didn't get to finish my.
Oh, you did not. I'm sorry.
No, that was he was reading another document.
Okay.
I couldn't finish my question, so
Sorry,
I wanted to finish the question so you actually respond to the question. My question was going back to 533, and it seems like you may have answered it. 533 to 556. Is the author's intent that this be applied to discoverable information, that we're recreating the federal rule regarding the failure to preserve electronically stored information, or is the author's intent to broaden this to apply to all forms of discoverable information?
I think that we were dealing specifically with electronic information in the subcommittee. I do believe that it would be the issues involved here, lawyer to lawyer, I do think would have a fair application to any type of document. The answer is, in subcommittee we're focusing on the electronic. I think that the full committee may very well want to apply it to any documents, and I think that would be a reasonable application.
Well, and that's kind of my concern, because I looked at this as being an e-discovery bill to deal with the nuances of dealing with e-discovery, electronic discovery, and so I've always read this in the context as we were trying to address the particular issue where a person fails or an entity fails to preserve electronic data as opposed to all other forms of discoverable information. And so I was thinking that we were heading in the direction of amending line 534 to include preserved discoverable electronic information. But it sounds like we're not headed in that direction. We're going to a
Well, we
different.
can go either way. I mean, you know, I'm you know, in response to the question.
Should be the whole thing.
From the chair, I could see where
Discoverable
it might be
information.
reasonable to apply it to all, but I think it'd be up to the will of the committee.
All right. Mr. Fleming.
My question went to some references you've made to some amendments.
Yeah.
I didn't know if that's what you were trying to look over right now. Someone had just handed to you.
Well, I don't have the staff I had when I was majority whip, so I'm trying to figure out where they went. And so I'm appropriating the chair's aid. Sorry.
No problem.
In the subcommittee the other day, in the subcommittee the other day, we had some folks come and testify about the burden of production.
Yes.
Some of this may place on medical providers.
Yes, and we do have that.
And that is the amendment. You have that one.
That is one of the amendments that we have.
Okay.
Let's hold up on the amendments
that
until we
answers-
get to that
I've been
stage.
holding up on the
I'll
amendments.
go through what we got.
I wasn't going to bring our
yeah.
attention to it if you had it
Yeah,
already.
just,
That's fine.
we'll bring it up later. Yeah. Mr. Caldwell?
Thank you, Mr. Chairman. Mr. Ed, in looking at this, and of course I was on your subcommittee, and what Andy brought up a few minutes ago, we keep going back and forth with, was this electronic or was this for all discovery? And it appears that, and I guess I'm making a statement and asking a question as we read it. One section that talks about e-discovery, and the next section that talks about full discovery. May not it be better if we withdrew this and get it put in a better place all at one time and represent instead of piecemealing it out with an amendment here and an amendment there, and get this specified where we're talking about purely discovery, or we just talking about electronic discovery? Because this bill looks like it's a whole new discovery bill, not just electronic.
Well, that's something the chair is going to weigh as we get to that stage.
Thank you, Mr. Chairman.
Yes, sir. Ms. Welch, you have another question?
Yes, thank you, Mr. Chair. Have we, Representative Lindsay, has the exceptional circumstances test that is being applied now in this new preservation paragraph, has that test been applied in federal cases to other forms of discovery than just electronic?
I think it's focused on electronic.
You said it has only been to electronic?
That's my understanding.
Okay.
Somebody in the audience may be able to correct.
All right, let's go forward from this section. Where's your next section of the bill that's been modified?
Dealing, probably the next substantive area that's been modified has been dealing with Section 9, which deals
Effective date?
which deals with how it's to be applied, and basically we have limited to going into effect January 1st, 2015, and to be applied to only civil actions filed on or after that date.
Okay, I'm puzzled by that because we usually have things that apply to procedural matters, changes of the law occur with the change of the law, as opposed to rights that are vested or divested may affect as to a specific date.
Yeah, we went back and forth on this, and the concern was, you know, you're going back and forth exchanging documents. You're in the middle of a lawsuit, and suddenly on January 1st, there are new rules on the road.
But is this not procedural though? In this application, how the case will
It is
be
procedural,
handled?
but the concern was whether or not in this particular situation, given the fact that we've got ongoing discovery, it would be better to keep things the same or not. And like I said, it was a tough call one way or the other, and I do understand the chair's concerns, and we could certainly revisit that issue.
Thank you. Mr. Jacobs.
Well, I would just add to that. I mean, the question was raised during the subcommittee meeting, and ultimately it was a judgment call of the subcommittee. But I mean, I do think it makes sense when we're talking about rules of discovery if you're in the midst of a 6-month discovery period or however long it is, that the rules of engagement for that process shouldn't be different for discovery served prior to that time than vis-a-vis discovery after.
Should not be different?
Should not be different. I mean, the rules of the road with regard to discovery shouldn't change mid-discovery process in a particular case.
I'm thinking a little different on that, but we'll get to the discussion on that point. So that Section 9 completes your review of it. All right. I think we've got some people who would like to speak to the committee on the House Bill 643. I've got Kristen Comer. I'm fine. Mr. Comer.
That's Coomer, Mr.
Coomer. I keep saying Comer. Coomer. Beg your pardon. Apologize.
Thank you, Chairman. Just came to ask you to consider maybe a little different thought on this as you're going forward. I read through the whole bill a few weeks ago, and my first thought on the requirements for a discovery conference in particular, and that's what I want to talk to you about, is the discovery conference piece in particular. That discovery conference and plan could potentially create an unnecessary burden for, in particular, small practitioners. Obviously, courts could create similar requirements by local rule. They could even choose to require the conference and the plan on a case-by-case basis. But the way the bill is written, one party can compel the court to follow this new process without any discretion for the court. I understand the need that the bill seeks to address, and I think there may be a way to give the bill more of an optional quality to preserve the discretion of the courts. If the bill incorporated just a couple of minor changes, it would seem more in line with the spirit of the discovery rules and the Civil Practice Act, which in general leave broad discretion to the courts. If you look at lines 266, 268, and 272, those are the lines that I'm asking for the committee to consider a change. Each one of those lines has the word shall, and in each of those places I'm asking the committee to consider changing those shalls to the word may. That would preserve the trial courts, preserve for the trial courts the discretion they already have. And in the process, in my opinion, you'll probably preserve some small town private practitioners, some sole practice attorneys like myself. And I'll just tell you on that point, in my experience, there are really two kinds of civil cases that I take. There are those cases that involve lawyers who are local or who are from other small town circuits like mine, and then there are those cases that we have what we call Atlanta lawyers on the other side. And the good thing about those cases
is that a derogatory term?
No, sir.
It is in there. Having appeared on that area.
If the shoe fits, Chairman.
Who would else like to speak to the committee?
I will tell you that the good thing about that is you usually can at least explain a higher fee in the case. Whether or not you can collect it is another matter. But you know, this year we heard the Chief Justice talk about the need for availability of legal services in Georgia's small towns. Taking away the local court's discretion would be antithetical to that end. And by removing the discretion, those firms that have a financial incentive to expand discovery processes will do it. I don't want to say automatically, but there'll be a lot of reasons for them to keep doing that. And while I'll probably never have a local lawyer type case with a request for a discovery order, if the bill passes and the governor signs it as is, I don't expect that I'll ever have a case with Atlanta lawyers that won't involve a request for a discovery conference, which will result in the court being required to then follow the rest of the process. So I'm asking you to just consider keeping that discretionary language.
And I think what Mr. Lindsay was saying earlier in explaining there was to be this option for the court.
Yeah, if you look at lines 218 of the revision, and this is an Atlanta lawyer that's agreeing with you, that basically we removed it from being from having one party force such a conference. It can only be done by either mutual consent of the parties or by order of the court.
I think what Mr. Coomer is pointing out is the fact that it reads over here, if you have the parties disagree, the filing of it is automatically going to compel the court to require there be a hearing, as opposed to the court considering the request and weighing the beneficial purpose of there being a meeting or an order entered, rather, by having discovery. So we're really saying, in our litigation, I say, as a Atlanta lawyer, I'm going to make him come to a conference up in Atlanta.
Exactly.
But point being is, I file with the court has the obligation to now call for a meeting, as opposed to the court can exercise that discretion to see whether it's a need to or not.
Yeah, but and I'm more than happy to work further on the language, but I believe that this is all discretionary upon the parties first agreeing to undertake this path. If they don't want to undertake the path at the very beginning, then you don't go through the additional steps. These steps that are set out in the bill are only set out. You only head down that path if you've agreed to do so, or if a court has ordered you to do so.
Where's my legal guru, Ms. Travis, on this? What do you agree with?
I agree with Representative Lindsay.
So it's not, you're saying it's not mandated when it says either party unable to agree, either party may, by motion, the court shall order a conference?
But you only get to that point after you've already agreed to head down the path. At the beginning.
The way this is set up, this app is set up, is there's a discovery meeting. There's three different.
Okay, the plan as opposed to the meeting. You're right. I'm sorry.
And there's a conference.
I'm sorry. It is a discovery plan, not the meeting that we're talking about. So what you'd have first happen is there would be a need for a mutual meeting, we'll call it, between the parties. That could be either called or not called by either party. And if one party says we're not going to call it, then there's no right automatically to compel the other party. You can ask the court to review it, consider the reason that's being requested by one party, and the court in its discretion then makes a decision, we're going to have it or not going to have it.
Right.
Okay.
Mr. Chairman, if I may, the only problem with that is you then, conversely, I think, and probably converse to the purpose of the bill, you create an incentive to avoid having a meeting to discuss a discovery plan. I don't want to do that, and I don't want to make it such that neither party can petition the court for relief. I mean, that's not the purpose either. My purpose is to say, rather than requiring that once the process is started, then the court has to do A, B, and C, instead at every juncture leave it to the discretion of the court to say that it's appropriate in this situation that we enter the order, or that it's appropriate in this situation that we require something further from the parties, rather than directing and frankly taking away the discretion of the trial court in planning the discovery process.
I think what I'm seeing the problem with it, Ms. Travis and Mr. Lindsay, is that it doesn't really specifically address that circumstances when they have the planned meeting and the one party says, I don't think we have a need to do a discovery order, and the other guy says, well, we do need to. I think we do. How do you then engage the court? There's nothing that says that, unless you can point out to me.
I'm trying to, 1264, if they're unable to agree on a discovery plan at a discovery meeting, so they agreed to have a meeting, but now they're disagreeing as to what the plan should be. They file a motion with the court.
Well, we've had, back up, trying to decide if they even have a need. Well, they have the meeting. They got to have the meeting regardless, correct?
No, they don't have to have a meeting.
That's what I'm saying.
Right, that's at line 218.
So they don't have a meeting. One side says, I want to have a meeting.
So then you and I are in litigation. I say we have to have a meeting, so I'm going to file a motion with the court.
And that motion is where?
Line 218. thought, it says or pursuant to.
No, it doesn't say that. That's what I'm saying. There's nothing showing how do you get to that point by getting the court to make an order.
Okay, I hear what you're saying. I guess I wasn't thinking that we'd need to spell out, you'd have to file a motion because it says court order.
If one party disagrees, the other party desires to have a order, it files a motion. And the court then will be reviewing in its discretion to decide whether to order or not.
Well, I'm not sure.
I wish to go back just to federal rule.
Yeah.
Federal rule is you shall have a meeting.
Yeah.
You shall consider. I mean, the point
Well,
we're trying to build so much what ifs in here, and it works in federal court. And it's not. I know you can say smaller cases don't need it, and both of them agree they don't need it. So be it. But one party says, "Well, I think we do need it. We need to have a meeting," and one party says, "No, I don't want to meet about it. I don't want to enter an order." There's got to be something to bring that forward for the court to do it without all the what ifs. You know?
The easy remedy here, if the chair is concerned about that, and the chair is to say, or pursuant to a court order upon motion of either party or the court or on the courts.
Well, again, let me ask. You're saying that by the filing of a motion, the court shall order?
No.
Without discretion?
No. The court does have the court, upon agreement of the parties or pursuant to a court order.
Well,
It's up to the court to decide whether or not to impose it.
No problem. Hold us tight. I think we got several people I want to hear from on this. Mr. Fleming, I think you were first.
Well, my question is far too simple to make any sense, and that is, what harm does it do on line 266, 268, 272 if you change shall to may? How do we harm the purpose of the bill?
I don't think we harm the purpose of the bill.
Because that's what Representative Coon was asking for.
266.
The problem, there is a problem on 268, but I think, because don't you want the parties to
Shall, if it's got that point.
submit their sides?
If I may respond to that particular question, I mean, none of us like the idea of inside baseball, and I'm not suggesting that, but I will tell you that if I've got there can be cases when somebody is coming from Atlanta trying to require something of me that I know my local court is not going to require. So why would I spend 4 or 5 hours preparing a document I know my court's not going to make me do in the end?
That's why I would say. Is that going to be true with every court?
I'm sorry?
Is that going to be true with every court?
No, but my point is, if you make that each party may submit a brief statement, if I think this is a legitimate concern and we really need to address this, I'm going to prepare the statement and have it ready at the conference. But if I think that the other guy is just full of baloney and wasting time, I don't want to have to prepare for a wasted conference.
I think the section is going to need some more work before we get to a stage where everybody's in agreement. Mr. Hold on, Mr. Jacobs. Mr. You wave? Okay. Mr. Jacobs.
Sorry, I mean to keep waving at you, but my light's been on the whole time. So, doesn't it solve this problem if we simply insert the word discovery before meeting on line 219? I mean, we're talking about you want to define how you get to a discovery meeting in the first place, and I think if you use the term discovery meeting right at the outset of our new Rule 26F, then it becomes clear later on that only if the court has ordered the discovery meeting that's called for here at the outset upon motion of a party or because the parties agree, and there's an impasse as to what the discovery plan should be at the discovery meeting, which is the term of art that's used there on line 264. I mean, I think it all becomes, I tend to think it all becomes clear if you just insert the word discovery before meeting on line 219. The discovery meeting is about the discovery plan. And the language on lines 218 and 219 is about how we get to a discovery meeting, but it doesn't say discovery meeting. But it does say discovery meeting later on.
Mr. Chairman, may I?
Go ahead, Mr. Comer.
I think that's probably helpful clarification, but again, I think by not fixing or not changing the shalls to may in Section 4, you still create an incentive or a disincentive for attending a meeting. Or you tell me there's no benefit to me in agreeing to the first meeting. I don't think that's a good policy either. I mean, I think it's better to have more open communication and figure out if there's a way to do things together. So I don't want to create a disincentive for an initial meeting in the process of trying to preserve discretion for the court.
All right. Mr. Welch? All right. Nothing further, Mr. Comer. We appreciate your bringing this to our attention. I think the next one we have is Matthew Smith.
I'll be excused.
Yes, sir. Please. Come forward, Mr. Smith.
Thank you, Mr. Chairman. And really, I'm simply here to make myself available. I presented last week. We did not meet, but at the subcommittee, what is now sort of being termed the medical community amendment.
Third-party production issue, right?
And it in fact has been quite narrowed since the discussion we had last week, because I heard the subcommittee's...
Tell us what your concern was and how that's been clarified, if you would.
Our primary concern is with the protection of non-parties who are going to be faced under the bill as written with requests for documents or requests for production of electronically stored information in specific formats. The bill allows the requester to specify the format in which the electronically stored information is to be produced. As I explained last week, there are a number of different formats or different forms in which electronically stored information can be produced, the simplest of which is simply printing off the record and handing it hard copy or burning it onto a disk.
Right.
That's very easy. There are other forms in which electronically stored information, can be produced and under the bill could be demanded. Those include what is known as native format, which is the electronically digital data without being loaded up on a screen on software. Also metadata, which is data about the electronically stored information. I couldn't tell you one of my clients who would know how to do that if requested it. And my clients respond to hundreds, if not thousands, of record requests every year. They would have to hire somebody to do it at a tremendous expense. So our non-party amendment really goes toward Rule 34C and Rule 35 and basically states, it creates a presumption, if you will, that a non-party who has no stake in the litigation, did not ask to be a part of it, satisfies their obligation to produce electronically stored information when they identify it and hand over a physical copy of it. There are times when a requesting party may need more. They may need a specific format, such as native format data, and they can, under our proposed amendment, show particularized need to the court, get an order from the court, but it will require the requesting party to pay the costs of having to search, retrieve, and produce that data. Very simply, that is our proposed amendment.
And that amendment's not currently incorporated into the bill?
It is not in the substitute bill. It is in an amendment that is before the committee. Yes.
Okay. Thank you, sir. Bill Clark and Alan Hamilton, Georgia trial lawyers.
Thank you, Mr. Chairman, members of the committee. I'm Bill Clark on behalf of the Georgia Trial Lawyers Association. Alan Hamilton is one of our members and is very well versed in this area, has worked with the chairman's working group and with the special subcommittee since its inception a couple of weeks ago. I want to give the 40,000-foot level view from GTLA's perspective and then let Alan talk with you about three of the areas that you've discussed so far and about which there will be amendments. But I think it can help clarify some of the issues that have been going around the committee discussion. Our initial position on this bill was, to the extent that it was about e-discovery, we were supportive of it. We're not aware of any cases where someone was not able to conduct meaningful discovery of electronically stored information because it wasn't specifically stated in the code. But if that's a problem somebody's concerned about, it makes sense to put it in the code. We were supportive of the concept. When we saw the bill as introduced last session, the end product of a task force, let me address that for a second. This is not a state bar bill. This is not a state bar proposal or a state bar initiative.
We're aware of that.
I wanted to make sure because it has frequently been referred to as a bar bill or a bar initiative. This is an issue that came out of a task force. The Georgia Chamber asked for the task force to be created. The president of the bar at that time agreed and put lawyers, as has been indicated, from both sides of the V on there. So defense lawyers, plaintiffs' lawyers, and others were involved. But key to that whole task force was a very strong-willed, fine, upstanding judge from Cobb County who made the balls and strike calls at the end of the day. This was not a consensus product. This was after the parties hashed it out, the judge made the decision this is what's going to be in the task force report. So that's what became the underlying bill. At that point, since then, we've taken a look at it. As I said, worked with the chairman throughout the summer and fall on the issue. We are opposed to the bill for a bunch of reasons because we believe it inappropriately, and so far we haven't heard a reason why it would be good to constrict parties' ability to conduct meaningful discovery. That's what this bill is about. It's about constricting. There are rational arguments about why you ought to do that, but understand that that's what you're doing here. You are constricting the parties' ability to engage in discovery and often to engage in meaningful discovery. That's why we have come to this in opposition. But we have worked with the working group and the subcommittee all these months and weeks, and we believe this bill is now close to the point where we would be willing to close our mouths, walk away, and voice no further objection to the bill if three significant issues are addressed. The premise of this whole exercise has been the need for uniformity between state and federal rules. I'll tell you, most lawyers practicing outside of Atlanta stay in state court rather than federal court for a number of reasons, but chief among those is to avoid the unnecessarily overly formal discovery rules that parties and lawyers have to comply with in federal court. So if you're going to go down this road, I want to ask you to keep two things in mind. Number one, be prepared for the wrath of a large number of the 40-some thousand lawyers that practice law in this state that intentionally stay out of federal court. And secondly, if you're going to go down this road, and I understand, as a wise representative reminded me earlier today, that the ship is sailing on this. It's not just an e-discovery bill. It is a broader reform of discovery. If you're going down that road, we encourage you to stick as closely as possible to the federal rule and the federal case law so that our lawyers and our judges all over the state know how those rules will be applied. There is ample Georgia case law, and frankly the federal courts will tell you, in the Seminole case, the Fleury case, says we don't really have federal guidelines on a lot of this discovery sanctions and what have you. We follow the applicable state case law, and in Georgia it's the Georgia case law. So follow the federal rule where there is one, and there is only one on sanctions. Follow the federal case law and the Georgia case law that lawyers and judges know how to apply. I'm going to stop now and let Alan take you through the three issues that are the most important to us. And again, we could find, I know we've got 10 different things that we're concerned about and our members are concerned about, and they're screaming from the rafters because they know this is going to constrict their ability to engage in meaningful discovery. But if we can address three of those issues, if you will address three of those issues in an appropriate way, we'll go away and not have any further objections. So I'm going to let Alan take you through those substantive issues, and I'll be available for any questions that you might have.
Good afternoon, Mr. Chairman. Thank you. There are three amendments that really spell out the substance of the changes that we believe are necessary, and it's not, in our view, a plaintiff versus defendant sort of issue. It is primarily about making sure we preserve the ability of all parties on both sides to have clarity and efficiency in seeking information that's relevant to disputes in our courts, and also, equally important, not burdening our trial judges who have a different different range and spectrum of cases versus federal judges, and also generally a larger caseload and shorter staff than their federal counterparts. But the first of these amendments deals with the scope of discovery right at the beginning of the bill. The amendment is AM 292269. And the first part of it, there are really two components to it. The first has to do with changing our standard for how we have defined relevance for 40 years, that being the subject matter of the action, with the federal language. And when I look at it, I still cannot clearly articulate what the difference is. And that raises an important question in our view. If no one can articulate a reason, that is it more narrow, and if so, how and why, then why would we change our standard for something so basic as the definition of relevance, which particularly, though my accent may betray, I'm not born an Atlanta lawyer. I sort of live in both worlds. I live here now. I know that any change you make like that to something so fundamental that we deal with in every single case will invite litigation, court cases, motion battles over whether the subject matter would have allowed me to get certain information, but the new tying it to a claim or defense does not. So that is frankly the lesser of the two concerns, but the burden in our view ought to be on someone to articulate a reason why we would change the fundamental definition of relevance in Georgia. The second is proportionality, which has been discussed at length today, and it's a very important discussion. The problem with putting proportionality up front in the definition, you're mixing it in the current draft, you're mixing it in with the definition of relevance. And that is not in the federal rule, and I'm not aware of any state where that is the law. Proportionality is covered by the limiting factors on relevant discovery in the amendment. And specifically, where that occurs would be line 46, inserting the phrase, what is proportional to, between considering and the, on line 46. And the reason that's important is we are down in the limiting factors, we are talking about what proportionality means. We are grounding that concept, that phrase, with the specifics that define it. The problem with putting it up front next to the definition of relevance is it overweights proportionality. And equally important, it invites a brand new boilerplate objection that will be made by every party responding to discovery on both sides of the V to every request in every case. And I dare say that if we took a poll of judges about their civil dockets, what they like least, high on the list would be discovery disputes that often stem from lack of clarity and candor among lawyers on both sides in defining what they are unilaterally withholding behind their own definition of relevance. There's a significant disproportionality of information at the beginning of a case. Now you ask me for a certain type of document, and I not only say, well, what you're asking for is not relevant, which we can kind of hash out. We're at least stuck with that fight. But now I get to say, well, it's not proportional. Says who? Says me at the beginning of the case. And it's going to be an unexplained boilerplate objection. Rather than putting it in with the factors that allow judges and litigants to have more clarity about this at an appropriate time in the case, we are creating a mess. We're creating the very opposite of our intended effect.
Thank you. Go forward.
If I can just pick up one point on that, the practical problem, Mr. Chairman, is that currently the way this is addressed is a party files a motion for a protective order. They say this is not proportional, this is a $200,000 request in a $50,000 case. And so they have to file a motion for a protective order. They have the burden of proving why that protective order should be issued. They know what evidence they have, they know where it is, the cost for retrieval. If you shift to use the language that's in the current substitute, you move that burden to the party that doesn't have the information, that doesn't have the ability to educate the court on whether it's proportional or not.
Understood.
The next section, if you want to pause for any discussion on that or just move on to the next section. The next section would be the spoliation provisions and sanctions therefore. And those Amendment 292265ER deals with this. This amendment tracks verbatim the current state of federal law and Georgia law, which are consistent on sanctions available for spoliation. It also, to back up at a high level, there is only one federal rule on spoliation sanctions, and that is the electronically stored information safe harbor that is currently in Federal Rule 37E. The amendment takes that verbatim and specifically protects ESI, or electronic information lost as the routine good faith operation of a system, and says there shall be no sanctions for this absent exceptional circumstances. And you learn something new every day. I had not thought of before today, I'm ashamed to say, what the point that Representative Evans raised, which in my view, in our view, is entirely correct, that borrowing the language absent exceptional circumstances, what that means in the safe harbor is the safe harbor assumes there's good faith. It assumes that nobody did anything untoward, and that a computer, because of our terabytes upon terabytes of data that we store in our warehouse, our computer in its routine operations has deleted information. And what the safe harbor does is it allows a court to still craft a sanction if there are exceptional circumstances. So in that context, exceptional circumstances means the evidence is so important, we have to have some sanction to address it. In the current draft that came from the subcommittee, you're borrowing a phrase that's looking to allow sanctions when there is good faith. And today we're actually pretty confused about what the language would mean, but it appears that the language now is borrowed as a code or an intent to mean you've got to have bad faith. The very opposite. It's taken out of its context in the federal rule and tried and used for a different purpose. And in fact, the earlier language, and I don't want to advocate going back to that certainly, but the earlier language of irreparable harm or bad faith as a litmus test is really, it appears pretty similar to this new language. Neither, though, irreparable harm, bad faith, exceptional circumstances, none of those litmus tests that we're batting around exist in Georgia or in the current federal rules at all.
What we had, let me ask you, what we had under the prior bill that started the process is if a party fails to preserve discoverable information that reasonably should be preserved in the anticipation or conduct of litigation, the court may provide for one or more of the following remedies. Is that what you're getting to?
No, sir. I certainly don't want to go back to that, but that is what it did say. There were remedies and there were sanctions. That was this allows remedies, but remedies do not really address. Permitting additional discovery about something that's gone is not going to address what's gone when it's important information. Neither is curative measures. I mean, the law recognizes that lost evidence, when it's important, is incurable. So, in effect, and it was accurately pointed out by Representative Lindsay, that in effect there's remedies, but there are no sanctions allowed at all under the current proposal absent this exceptional circumstances. That does not exist in the federal rule. The federal case law, the Fleury versus Daimler Chrysler case, if you look at it, it is exactly what is in this bill. It has a direct quote from the 11th Circuit Court of Appeals that states federal law looks to its own rules for spoliation sanctions. But then it says, we don't have a rule, and so we're going to look at Georgia because Georgia's rules are, quote, entirely consistent with federal law on the point. So it goes on to use and borrow from the Chapman case in Georgia, where certain sanctions or certain factors are laid out. We have those factors are brought directly, verbatim into this amendment. Critically, those factors, and that's at the bottom of page 1, it would be the replacement language at lines 555 and 556. Those factors require the trial judge to look at certain things, including good or bad faith, whether the prejudice can be cured, before issuing the most draconian of sanctions, the harshest of the sanctions, which are dismissal or default. Georgia law and federal law have long recognized and need to continue to recognize A judge should have the discretion when the evidence is important, even without bad faith, to have some level of sanction, not more discovery that won't deal with the lost evidence, but at the very least a jury charge that is and should be routinely given when material evidence should be preserved and is not.
Mr. Lindsay, you have a question?
Yeah. We were attempting to simply go with the existing federal rule rather than and simply allow for the federal court's case law. Explain to me, given y'all's new amendment, explain to me why you would be opposed to simply going with the federal proposed rule, which may be even cleaner.
The federal proposed rule is much closer to this draft. The proposed rule would create a new litmus test, and it is public comment closed on February the 15th, I believe. It is it's extended through today. It is a long way from a final product.
I recognize that. I recognize, and that was the original reason for my not wishing to do so. But given some of the points that you've been raising, tell me substantively why we should not simply go with the proposed federal rule.
It is good that trial judges have discretion to weigh the prejudice to the party who had the evidence lost versus the culpability of the spoliating party, and have some sanction available, at the very least a jury charge, even when there is not bad faith. And that the federal proposal would go in a totally different direction and create more clarity in the law. I'll give you that. It does create more clarity at the expense of innocent parties who have evidence that's critical spoliated. Because now, if there's not bad faith, there will be no sanction at all if that federal proposal ever takes effect. Whereas in Georgia and in current federal law, the most draconian sanctions have specific factors that have to be weighed. But the lesser sanctions, it is understood, trial judges need the flexibility to have some sanction directed to helping try the case in a more fair way when there's spoliation of important evidence. And so the current law is plenty clear enough and much better and fairer to all parties than the federal proposal in our view.
If I can just add to Representative Lindsay's question, what everybody needs to keep in mind is spoliation doesn't just happen by a defendant. Sometimes it is the defendants.
And I recognize that fact. That's not. I'm just trying to provide some degree of clarity. But what we're talking about is, in effect, a punitive action by a court. And punitive actions usually, in other circumstances, usually require some type of bad conduct by a party. Now, quite frankly, I was trying to avoid going down this road, but since we seem to be getting more and more murky, I'm wondering whether we should just go back to the proposed federal rule, in which we do accept the fact that you can only oppose a penalty when you prove that someone has acted in bad faith. I'm just trying to figure out why we shouldn't just do that, given I was trying to provide some clarity, but I'm beginning to wonder whether or not in the attempt to provide a middle road, we provided more ambiguity and we wouldn't be better off simply going with the proposed federal law. Now, I haven't made in my own mind a decision on that, but I'm just asking now.
My answer to that, Representative Lindsay, was that from the beginning, the proposal has been to adopt federal law and federal rule and federal case law. And the federal case law says you weigh. There are some cases where there was no harm done, but there was bad faith. There should be a penalty. There are some cases where there was no bad faith, but somebody was really harmed. They were completely taken away from them. The Fleury case is an example. The defendant argued successfully that we have no ability to defend ourselves because the plaintiff spoliated the evidence. There's no evidence that the plaintiff was in bad faith, but the harm was so bad to the party that there needed to be some remedy, some sanction. And so the courts, the federal courts and Georgia courts say, weigh the evidence and let the judge who is best positioned to make the decision make that decision. Don't put in place some draconian line that says every case has to clear this hurdle before there's to be any remedy or sanction imposed.
All right, we're going to need to move forward because we're running out of time. Certainly. Next one.
The final amendment had to do with cost shifting as a routine matter. Bill, do you have the line slide on that?
I do.
and the amendment is 292268, and it would affect lines 271 and 272. Currently, it is in federal and state court, it has long been the presumption that cost of copying, hard costs as they've been referred to, can be passed along to the requesting party. But for very good reason, soft costs, if you will, that is paying lawyers to review documents, to gather documents, paying e-discovery vendors in this brave new world we're in with e-discovery, is typically borne by the responding party. And the reason is, if you ask me for documents and I know that I can pass the full bill along to you, I now have a very perverse incentive that is very opposite to the goals of efficiency in discovery. I want the bill to be as high as possible. I want to bury you with costs to get the information. And so that's why the law has for a very long time, there are U.S. Supreme Court cases on the point that costs of retrieving the information cannot be passed along. So without the amendment would change it back to be clear that we're talking generally about out-of-pocket costs for document duplication. In the event that we want to shift other costs, that is e-discovery vendor costs or manpower costs in an exceptional case, there is currently in the protective order provisions of the Civil Practice Act, and it's long been the case that a party who feels the discovery is unduly burdensome in terms of cost can go to the court and say, if they really want this, then for X, Y, and Z reason, the requesting party ought to have to pay for it. We should preserve that balance. Simply inserting allocation of costs without some limiting language that expressly preserves the presumption, that was a mouthful, against cost shifting to the requesting party would create confusion and frankly would lead to inefficiency and greater costs and burdens in discovery than we currently have.
All right. You use reasonable out of pocket as opposed to reasonable as a term. I guess out of pocket, reasonable and actual cost.
That is the language that's there. That I'm not sure how good of a statute term out of pocket is, but reasonable copy duplication or copy costs might be better.
Okay. Any questions on that amendment? I appreciate you bringing them to our attention, and they're going to be considered.
Thank you, Mr. Chairman and members of the committee.
Thank you. We have no one else who has signed up for the purpose of addressing the committee. I want to just ask, does anybody else want to say anything briefly to the committee who may be here? If not, we will close off further public input. The bill is now in the breast of the committee, and let me, as a chair, suggest we've got several things I know we're looking at as amendments. We're going to go through the amendments. We will have amendments either adopted or rejected. Once that is concluded, we're going to have a bill prepared with the amendments before we go on further proceeding to the final resolution. I think we have some things. We're still looking at getting some potential language prepared. So at this meeting, we're going to address only amendments that have been prepared and presented. There are some things that we've heard talk about that need to be potentially worded that are not before us. I've tried to address in the notice to the committee members. I wanted all the amendments, unless it's a punctuation, clarity, or something of that nature, made in writing. I have before me three amendments.
Mr. Chairman, they're making copies
of your amendment. Okay.
What? I don't know where they went.
Yeah, I don't know either.
Yeah, we have three copies. The ones that we're talking about, the least I had in my folder, is the 268, 65, and 69. First, let's have a motion on the bill. We have before us LC 295905 ERS. Do we have a motion of the bill? Motion is due pass. Is there a second to the motion?
I'll second.
All right, we have a second to proceed with the consideration of the bill. Do we have any amendments to the bill? Who's presenting amendments? Mr. Welch?
Mr. Chairman, I'd like to present to the committee for consideration AM 292269. This is the amendment that would amend the scope of discovery on lines, beginning on lines 26 and then making variable changes through line 47.
All right, you have 2269 is proposed as amendment. Is there a second? Second. It's been seconded. Discussion on the motion. You're not wanting to discuss that. Any further discussion on the motion?
No, Mr. Chairman, I've already covered why.
All right.
The language, looking language.
Mr. Travis, you're looking painful.
We'll, on line 8,
The change in litigation to action.
line 8 of the amendment.
Replacing litigation with action.
Civil act?
That would actually be more appropriate. Yes. Mr. Chairman, may I amend the amendment by inserting civil in front of the word action on line 8 of the amendment?
I'll take that as a friendly amendment. And the amendment now is 2269 with the word on line 8 inserting civil before action. And still have a second for that, I believe. Is that right? Any discussion on the motion? None. The chair will call for a vote. All in favor of the amendment 2269 signify by saying aye. Aye. Opposed, like sign. Motion carries. Next amendment, is that yours also, Mr. Welch?
No, sir, it's not.
You have an amendment, Ms. Evans? State your amendment.
Thank you, Mr. Chairman. I have two. First, AM 292268.
All right.
Which deals with the last point that we were discussing with the last witness about ensuring that we're not routinely shifting soft costs such as attorney's fees, but we're actually dealing with the costs that the law currently contemplates. And I believe Representative Lindsay, when we discussed earlier, actually agrees with this. And I think if we want to change, I don't have any problem with changing out of pocket to something different. I was thinking maybe actual.
Reasonable
but that's
and actual,
my
or reasonable?
Reasonable actual costs.
Right.
That's my amendment.
Second.
All right. The motion is 2268 was changed out of pocket on line 2 to place it instead actual, so reasonable actual costs for duplicating, etc. The second to the motion. Discussion on the motion. Mr. Fleming.
Mr. Chairman, Representative Coomer came to us earlier and talked about making some changes in that very area, if I'm not mistaken.
Yeah.
That was changing the words shall to may. I think we're about to address at least line 72.
I'm going to.
It doesn't change. The Representative Coomer
We're past that point.
Shall is in
the next.
What Mr. Coomer may want, we're going to have to get done by a prepared written amendment before we consider it. So that was my ruling. Stands. He's made expression. The bill is not going to be voted on today. If you want to deal with that issue, you're welcome to have a proposed amendment put together.
Thank you, Mr. Chairman.
We're on the 2268 amendment. Further discussion. Mr. Lindsay, do you want to address it?
A question to the author of the amendment. Are we now going to restrict a party who's defending an action from ever being able to recover anything other than copying costs?
No, certainly not.
Where within the bill are they going to be able to seek those additional costs?
Well, the bill doesn't address that at all. This is simply within the section where the parties may come up with a discovery plan or the court may address the discovery plan. The ability for the responding party, whether defendant or plaintiff, who wants to say that the burden of producing documents for all reasons, e-discovery vendors, attorney's fees, whatever, they still, as they always had, the ability to petition the court for that relief, showing an undue burden. That doesn't change.
I understand the desire not to shift costs for attorney's fees, but I'm not so sure why we are at the outset limiting it to duplicating documents. I can understand, for instance, simply just replacing the existing language with reasonable out-of-pocket cost, and then allowing the court to determine what out-of-pocket costs are reasonable.
Because of the stage of the case that this section deals with. This stage of the case is before we've even started discovery.
I understand that, but
and so we wouldn't want to set out a rule from the beginning that there would be a presumption in the other direction.
I'm not creating a presumption in the other direction. I'm just trying to keep a presumption from being created the other way. I'm simply just saying, why don't we just say reasonable out-of-pocket cost? I'm suggesting an amendment to your amendment, simply just saying reasonable out-of-pocket cost.
Are you saying to say reasonable actual costs and no more?
Saying reasonable out-of-pocket cost.
Out-of-pocket.
We've changed it to actual.
We changed it to actual.
Yes.
Reasonable actual cost.
Reasonable actual cost.
Yeah.
Just go with reasonable actual cost. For producing electronically stored information.
I don't accept that as a friendly amendment because I think it changes the purpose of the amendment.
Well, I think what it does is it sort of keeps things neutral at the early stage of the litigation. So, Mr. Chairman, my proposed amendment to the amendment would be to strike out of pocket, put in actual, and strike for duplicating documents to be produced or producing copies of, and simply just put in for producing. Basically, what the sentence will now read is reasonable actual cost for producing electronically stored information, and keep that neutral as to whether or not the cost should be copies alone or should be additional cost, and let the parties determine that depending on the facts of the case.
All right, that is the amendment to the amendment. Is there a second to the proposed amendment to the amendment, the Lindsay amendment?
Second.
It's been seconded. Any discussion on the Lindsay amendment to the amendment? We have discussion by Ms. Oliver.
This is really a parliamentary inquiry, and it's totally your call. We are varying from the rule that we were going to have amendments.
Well, you're right, but you have an amendment to the amendment, which is
a distinction.
The chair is accepting amendments to the amendments are in writing.
Chair.
Correct. I just want to be clear on that. We're looking at amendment to the amendment. It's been seconded. Any further discussion on the Lindsay amendment? If not, call the question. All in favor signify by saying aye.
Aye.
Opposed, like sign.
No.
The chair rules the noes carried it. We're back to the main amendment, which is 2268 with the insertion of the word actual, which I think has been taken as a friendly amendment. No further discussion on that.
Yes.
Any further discussion on the Evans amendment? Not the chair will call the question. All in favor of Evans amendment 2268 signify by saying aye.
Aye.
Opposed, like sign.
No.
The chair rules the ayes carry it. Next amendment. Does anybody have further amendment to offer?
I have one other amendment, Mr. Chairman.
All right, Ms. Evans.
AM 292265, which deals with the section about destruction of evidence, spoliation, and what this amendment does is tracks exactly the language of the federal rule, which can be found in lines 27 through 29 of the amendment. That's the only federal rule on this issue, and it's verbatim. And then the rest of the language tracks existing federal case law about the factors and situations for consideration when a court is determining an issue of the proper remedy or sanction for spoliation. That's my amendment.
All right, discussion, is there a second on the amendment? Been seconded. Discussion on the amendment. Anybody have discussion? There being no further discussion, Chair will call the question on the amendment 2265 offered by Ms. Evans. All in favor signify by saying aye.
Aye.
Opposed, like sign.
No.
Motion carries. Further amendments. We have further amendments. Is this an amendment? 2266, 2271. I'm looking at two documents here. Are these yours, Mr. Lindsay?
Yes, yes,
All
sir,
right.
they are. Basically going back to what we're trying to do in terms of simply tracking the existing rules, line 135 to 142. It's been suggested to us that we have deviated from the existing federal rule language, and basically what this proposed amendment will do is simply track the exact language from the federal rules regarding the production of information and the inadvertent withholding of information, so that we simply just are tracking the existing federal
So
rules.
they produced it inadvertently, and now they're giving reasonable notice,
Yes,
or
sir.
time, notice in a reasonable time of that fact, and the producing party shall preserve the information until the claim is resolved.
Yes, sir.
Okay. And that changed from the current language to what? From what?
From the more expansive language we have in our proposal to the exact language contained within the federal rules.
All right. Is that the, as you come down, the other amendments all still address the same
Yes, sir.
thing, correct?
They all did. Yes.
Thank you. Discussion on the amendment. Is there a second, first of all?
Second.
We have a second. All right. Discussion on the Lindsay Amendment 2266. Any discussion? Ms. Evans?
Thank you, Mr. Chair.
Yeah.
Just a question. What is the effect of taking out the words "or attorney work product" on line 116?
The attempt is simply just to basically track so that we can rely upon federal case law to make sure that we're simply tracking the exact same language.
Do you think that attorney work product is contained within
I
trial
did.
preparation?
Yeah, I did.
All right. No further question on that point. If there are any other questions, if not, the chair will call for the vote on Lindsay Amendment 2266. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Further amendments, Mr. Lindsay?
Yes, sir. 2271 touches on the proposed language that was discussed by the attorney for entities that have to receive and respond to a large number of non-party requests, and it simply allows for them to respond to discovery requests in the cheapest manner possible, and also to recover the reasonable cost for doing so. And if additional methods are requested to the non-party in terms of responding, in particular dealing with electronically produced documents, that those additional costs be borne by the requesting party and only take place upon an order of the court.
All right, so that goes to the lines at 619 primarily,
Yes, sir.
right? Is there a second to the Lindsay Amendment 2271?
Second.
It's been seconded. We have discussion. Mr. Fleming?
Mr. Lindsay, this is the one that we talked about earlier where the folks came about the medical production of documents.
Well, yeah. In particular, the medical folks would do that, but it would deal with any type of non-party.
But what it does is, and correct me if I'm wrong, is that instead of using the word production of, it also includes production, but says retrieval and conversion. And that's getting into the computer aspects of electronic discovery,
Yes,
right?
as was discussed by the gentleman earlier. Yes, sir.
And then the second part down there, starting on line 8 of the amendment, that's where we basically state that if you produce them in physical copies, which you've always done, that's fine.
Yeah.
But if you're going to get into the electronic portion of it, if you ask them to get into what they call metadata and other things, then the person wanting it has to pay for it. Is that what it
That's
does?
essentially what it's going to cost.
Okay.
Mr. Welch.
No, I wouldn't.
Ms. Evans.
Just because I can't read fast enough, thank you, Mr. Chairman. I have a question for the author. I understand we're adding this to the section dealing with non-parties on line 374, but what these sections on line 619 and 652 to 653, does any of that apply to parties?
No.
I believe it does. They narrowed it down so that it does not. Let's take a look there.
Any further?
No, thank you, Ms.
Anyone else have a question of the presenter or comment? If not, the chair will call question, which is a due pass of Lindsay Amendment 2271. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Do we have any other amendments prepared? If not, the chair is going to call your attention back to page 16, and just as title we have on line 533, which is the failure to preserve electronically stored information. And as this deals with a broader scope of discovery than just electronic information, I'm going to propose amending that to say failure to preserve discoverable information. Did we? Oh, did this? Okay, I wasn't catching that. Thank you.
So good, you already did it.
How you know? No further amendments. What we're going to do at this point, I'm going to suspend further consideration on 295905 to allow Ms. Travis to prepare what would be another draft of the bill incorporating all amendments which have been approved, and that will be transmitted as soon as she has it prepared. We'll get it out to everyone on the committee to look at ahead of time electronically. And we'll consider it from that standpoint. Okay? Thank you.
Thank you.
We have next Mr. Brockway. Mr. Brockway, come forward with House Resolution 1215. I might also, did Judge, I lose my judge? Judge Hambrick. Thank you for being with us. Sorry to get to oh my goodness. Judge Edlin, nice to see you today. Thank you for being with us.
There's Judge Hambrick.
There's Judge Hambrick of the Coweta Circuit. Thank you for being with us. I apologize for not recognizing both of you earlier.
It's really scary.
Good to have you here.
And also tweeting about you as you do it.
Mr. Brockway, thank you. Glad to have you with us. If you would
Thank you,
tell us now about House Resolution 1215.
Thank you, Mr. Chairman. I appreciate you adding us to the schedule today. Ladies and gentlemen of the committee, I bring before you House Resolution 1215, and this is a call for an Article 5 convention. I know you debated a measure along those lines yesterday, so I won't go into what an Article 5 convention is. I'll assume that you remember that, and I'll be happy to answer any questions as best I can on that topic. Basically, this calls for an Article 5 convention of states based upon certain limited topics, and you see that beginning in line 17 through 23. It calls for a convention excuse me, limited to proposing amendments to the U.S. Constitution that impose a fiscal restraint on the federal government, limiting power and jurisdiction of the federal government, and limiting the terms in office for officials and members of Congress. That very simply is what the bill does.
Let's keep the door shut. I know, just suspend for a minute till we get that
Sure.
door closed.
Thanks, sir.
It's hard for committee members over there, I know, to hear with that door open. Please shut the door. There we go. Thank you. Go ahead.
Thank you, sir. So it calls for an Article 5 convention based on those three topics that you see there in paragraph starting in line 17 through 23. How this is different than, for example, what you debated yesterday in the balanced budget convention call is it allows us to bring forth multiple amendments. So a balanced budget could be one of the amendments. You could also, as you see here, the last line there, debate the terms of office for members of Congress, for other federal officials. So it allows us to address other issues in addition to the idea of a balanced budget. And the reason that I bring this particular one forward rather than others, I support other efforts that are going on to balance the federal budget, but I believe there's other areas that we need to address, other areas where I think the federal government is intruding into what I believe are the proper roles of the states, and this proposal would allow us to address those sorts of amendments in addition. So,
all right.
Thank you, sir. I'll be happy to answer any
questions.
questions.
With you today?
Yeah, Mr. Golden Shoe is with the Organization Convention of the States, which is working with us on.
Before previously.
Yes, sir, and thank you for the opportunity to be here on House Resolution 1215. This bill is also identical, virtually identical, to Senate Resolution 736, which was passed, has been passed, and crossed over to the House. Again, I think as Representative Brockway represented, there are 3 limited topics in this bill designed to address a series of issues, and I would simply say that I know you're all familiar with Article 5. This is intended to try to address multiple issues in Congress. It would rather overreach of the federal government. It is an overreach that has occurred through multiple administrations and multiple Congresses controlled by both parties. There is certainly nothing unusual about having, while limited, multiple potential amendments. The fact is the first Congress of the United States proposed 12 amendments to the Constitution, 10 plus one other that were later submitted. And all of this is consistent with the intent of the framers and founders when they gave us this very wonderful Article 5 gift. The Convention of States project is now organized, even though it was just announced in August, is now organized in 43 states. We are all volunteers, and there are literally thousands, well, by now tens of thousands of supporters against this. Georgia has the wonderful opportunity to be the first state to pass this proposed resolution, and we would certainly, I'm available to answer any questions that you may have about the scope and the limits of this proposal, but we would certainly love to see Georgia be the first state to adopt this resolution. Thank you.
Mr. Welch.
Thank you, Mr. Chairman. At the appropriate time, I'd like to move the bill, but I wanted to just express one concern to the author of the bill. I support the measure, but in supporting the measure, I just wanted to note that in the limit of the terms of office for its officials and for members of Congress, I do have some great concern with this concept because out of all the people that are affecting and influencing the federal government and state government, which would include the members of the administrative agencies and would also include the special interest lobbyists that are exercising their right to influence legislation. It concerns me that the only out of those two groups, and the additional group are the political leaders themselves, are the elected representatives of the people. Out of those 3 groups, there's only one group that is the voice of the people directly back home, charged with that constitutional legal responsibility to represent those people. And I fear that a term limit, depending on how narrow and how limited that term is, you would actually be adversely affecting the voice of the people in government. And so enhancing, perhaps unintentionally, enhancing the voice that is very loud with respect to special interests and is very loud with respect to the administrative or executive branch of the government. So I just want to make sure that you've heard my concern with respect to that. Nevertheless, I am supportive of the measures, the other two measures that are contained in this resolution.
We're going to have a consideration of this bill to get it upstairs before 5.
Yes, sir.
I want to be quick with it.
Yes, sir.
If you got something really important you want to put on there, it's 10 minutes to 5
I'll
now.
I'll just say I share your concerns, and nothing in here obligates anybody to vote for any amendment that may come out of this. So, thank you. Thank you, Mr. Chairman.
And your Judge Caldwell?
Yes, sir. I'll ask you, sir, the exact same question I asked the senator yesterday when we had his bill over. And that question was, and I used the terminology that's been thrown about, how do we defend or stop a runaway convention when we just call for a convention of states? And in his bill, and his answer to me yesterday was, well, we can do Georgia. And I said, yeah, you can control your Georgia delegates by your bill, but you can't control the other states' delegates. How would this bill prevent, or will it prevent, a runaway convention so they could add anything they wanted to? You understand what I'm saying? Any
Sure.
amendment, not just the ones described here.
I'll answer very quickly, Mr. Chairman. Amending the United States Constitution is there's an incredibly high bar. It takes 38 states. We have red states and blue states. There's not enough red states to amend the Constitution to support some things that maybe perhaps that I would want. So I think that this the very nature of this process forces us to the political middle. And so I don't think that, I think it's almost impossible that we're going to have an amendment that's even going to come close to passing that is going to be what folks would consider outside the political mainstream. I think the danger is, from my mind, that you never get to a convention because the bar is so high. You have to have 34 states to even have a convention. So I think, I understand your concerns. This is something that has not happened in American history in a long time, but
Never.
I think the process is such that
Never.
we are protected.
All right. No further questions. The chair will entertain a motion. Move do pass.
Second.
Been seconded. Discussion on the motion. There is no discussion. The chair will call any amendments. No amendments. The chair will call the question. All in favor do pass resolution 1215 signify by saying aye. Aye. Opposed, like sign. No. The chair rules the motion passes and the resolution is approved.
Thank you, Mr. Chairman. Thank you, members of the committee.
Thank you.
All right. Next we have Mr. Gravely. House Bill 449. Yes, sir. Your bill's been before us previously, I believe, has it not?
Yes, sir, Mr. Chairman, it has.
And let's get that noise down again. House Bill 449. Please proceed.
Thank you, Mr. Chairman. I will be brief. House Bill 449 was originated out of Douglas County, Georgia, and very briefly in 2009, a 22-year-old woman was coming home from work during what is called a 500-year flood.
Go ahead. I'm sorry. Keep the door open and noise.
Yes, sir. Many of you will recall the 500-year flood that devastated parts of Douglas County, South Cobb, and Paulding County. And this young lady was careened off the road over Sweetwater Creek. She made a 911 call to the Douglas County 911 Center. For 22 minutes, this lady was on the line with a dispatcher. There were prayers, dispatchers trying to get to her. Inevitably, her death was captured on the audio recording of the call, which brought to attention the availability of those particular calls to be accessed by the public. There was an open records request submitted by a news agency here in our state, much to the horror of the young lady's family and her husband, and it brought about questions about our current law. And what with the beginning of HB 449 was a very broad bill. It had a lot of fluff in it, And I think due to the work of Chairman Jacobs, Representative Evans, and you, Mr. Chairman, I believe this bill has been perfected with the language. It actually appears now to be the original intent of the bill, and I very much appreciate everyone's work on it. The bill is currently and has remained supported by the Georgia Commission on Family Violence, the Georgia Association of Chiefs of Police, the DA's Association of Georgia, the Georgia Solicitor General's Association, and the Association of County Commissioners.
So what we're doing, we're denying the access to the voice 911 telephone recording of a person who, as a part of that call, becomes deceased.
Yes, sir, and if I may.
Except for certain defined 5 areas.
Yes, sir, Mr. Chairman.
Or 6 areas, excuse me. And those are listed A through F, correct?
Yes, sir, and if I might add, Mr. Chairman, though we are prohibiting the audio portion, the text or the transcript of these particular calls are still available to the public.
All right. Does anyone have any questions of Mr. Gravely? Oh, you do? Yes, sir.
Mr. Gravely, did Holly Manheim?
Holly Manheim, yeah.
Did she sign off on this one?
I don't know if she has signed off on this bill, but we have been in communication with Ms. Manheim, as well as several other advocates for, I believe, the print media and others that would have an interest in this particular bill. I spoke with them very briefly out front, showed them a copy. We've been very transparent in allowing them to be a part of this process.
So they knew you were going to be here today
yes,
with
they
this,
did know.
and they're not here?
Yes.
Gotcha. Okay.
Further questions or discussion? And there's no one else signed up to speak to the bill. Thank you, Mr. Gravely.
Thank you.
We'll cut off further public comment. The bill is now in the breast of the committee. We have a motion to pass. Seconded. Any discussion on the motion? Any amendments to the motion? There being none, the chair calls the main question, which is do pass House Bill 449, and that's LC number is 5899. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries.
Thank you, Mr. Chairman.
Thank you, too, Mr. Abbott. We have one remaining matter. Mr. Weldon is not here. Yes, sir. You can. House Bill 889 is called for consideration.
Thank you, Chairman. This is just providing a cause of action for those that engage in unlicensed practice of law, so that you'll have the opportunity to maintain a civil action, recover damages, attorney's fees, and expenses of litigation.
All right, and this is a bill. I think we have John Taylor in the audience. Mr. Taylor, come forward, please, sir. Appreciate you being so patient with us all this time. Identify yourself and who you represent, if you would.
I'm John Taylor. I'm the chair of the Legislative Committee of the Real Property Law section of the bar, and which was the originating section for this particular proposal. The Real Property Law section suggested through the Executive Committee, went through the Advisory Committee on Legislation, and then was approved by the Board of Governors. So it is a state bar initiative. And it came out of the Real Property Law section largely because the issue of the unlicensed practice of law and its effect on consumers has been heavily has heavily occurred within the real property law section, especially with residential transactions. It's also been an issue within the immigration practice and the bankruptcy practice, with non-attorneys providing services for consumers. Right now, the quote-unquote remedies for the unlicensed practice of law is through solicitors, and the bar is going through an active process to try to educate solicitors around the state that there are criminal remedies available. The pursuit of those remedies has been, as according to what I understand, few and far between. However, hopefully the education efforts will improve that. And also there are potential remedies through the bar and through cease and desist orders if those are found necessary and appropriate. However, there's nothing really in the law right now that would provide for a remedy and recovery for the consumers who are actually the ones personally affected by unlicensed practice of law and the effects of them. And this would help to address that lack. And I'll be happy to answer any questions to the extent I can.
Questions of the Mr. Taylor? You have a question?
I have one, yeah. Thank
Do
you
that.
for coming today. If I go to a website like LegalZoom, for example, and I get a will off of there, or I try to get a will or some document, are they practicing law?
We contend that they are.
You contend that they are.
Yes.
So if you contend that they are, and we pass this bill, then we would be creating a civil right of action against them, correct?
That you would be creating a civil private right of action. You would not be modifying what the quote-unquote practice of law is. We're not purporting to affect the substantive definition of what is practice. If what they're doing now is then licensed practice, it would continue to be. What this would be would provide a right of action to an individual who relies upon that word is damage.
The you know, there's another bill that you may or may not be aware of that's gotten a lot of attention called the Uber bill, and it's where, as I understand it, we're going to attempt potentially to regulate. You call this service on, you know, or you don't call them. You hit an app on your iPhone and they come pick you up. It's you know, it's not a taxi, but it's something that the taxis hate, evidently, and we've been asked to regulate it. And what I have concerns about that, because when we get to the point of potentially telling the public, yes, somebody has innovated some way to help you, and then all of a sudden we're going to say to them that's illegal now, or that's not going to be as easy as it used to be because we changed something. I want to make sure we're not on the wrong side of this. Now, on the other hand, as an attorney, I make a heck of a lot more fees off someone who doesn't come to me first and goes to one of these websites and screws up, excuse my French, you know, for, you know, something. So it's very bad for folks to get legal advice from somebody who doesn't know what they're talking about, because it messes up important things for them.
Mm-hmm.
But I'm trying to strike the balance in my mind between us not saying you can't have a website that can give you some forms versus saying, you know, we don't want people practicing law without a license.
Mm-hmm.
I think that's very valid. That's what I'm trying to figure out in my mind.
Mm-hmm. If I might address a couple of things.
Yes.
To confirm one of your observations, anecdotally talking to attorneys who deal with foreclosure fraud and other issues, for example, in the real estate area, they estimate up to 80% of the title and mortgage issues they run into result from transactions that were closed by the various non-attorney firms that throughout the country that are coming into not unlike LegalZoom, start with document production and then move to the actual closing process. To your other question, I would emphasize again that what we are proposing is not a substantive redefining or description of what is or is not the unlicensed practice. Taking, for example, your analogy, defining whether or not what they're doing is done we're not getting into that. We're just saying, taking the substantive law where you find it now, the one piece that we think is missing within the enforcement mechanism is the right for a person who's actually hurt by what they're doing and they relied on this work to have a right of action against the people that did the work. That's not there right now. Last I counted, there are 14, 15, 16 states that now provide for a private right of action in this setting. So it's a recognized problem, especially since 2008, with various mechanisms to people both making money and purporting to save money for people. And like you said, there's the argument up front, well, look how much money we're saving the consumers. When you look throughout the process from the time, for example, a transaction is closed to the time he's trying to fix the problems, it may or may not save anybody any money.
Cost a whole lot more to fix it later. I know that.
Mr. Bruce.
I apologize. This is the first I've heard of this bill, so I want to make sure, because I'm going through something personally, and the comments that were made a moment ago kind of sparked my attention. But there are times when people are like in the hospital or sick, they assign the power of attorney to somebody who is not an attorney. And, you know, asking them to make decisions on their basis for them, and some of those may be legal decisions. Does this interfere with that in any way, shape, or form?
No, this proposed bill relates to unlicensed practice of law as defined under two specific sources. One is the statute that purports to define what the practice of law is, which doesn't get into any of the areas you're talking about, or it's the unlicensed practice as defined by the Supreme Court in their opinions. But when you get into powers of attorney in that kind of setting, that's not the practice of law like this would contemplate.
Okay. Yes, sir. All right. Ms. Oliver.
I think I'm a few sentences late to this conversation. Did this come through the State Bar Legislative Committee?
Yes, ma'am, it did. This is a State Bar approved proposal.
Last year I was watching the Legal Zoom bill. I'm glad you asked that question. There was a Legal Zoom bill, what we called it.
Still is.
Is it? It's still around.
Still around.
And
but actually, I'm sorry. Excuse me.
I don't use LegalZoom, so I don't know whether it has all its disclaimers on it, like the websites from the family law section of the DeKalb County and Fulton County and the Atlanta Legal Aid websites. All of those offer forms, and all of them have these disclosures that says, we're not practicing law, good luck.
Mm-hmm.
Are you saying that, and I'm very mindful of Justice Thompson's speech about access to justice, and that other states are doing a great deal more in terms of through state bars and through county courts with legal self-help. So, legal self-help is not a term of art, but you know, there are some states that are state bar associations that are putting kiosks out places to help people with access to documents and forms. I'm trying to figure out, when you said this criminalizes, or excuse me, makes civil liability for LegalZoom, how does it impact all the other nonprofit crowd that's also trying to deliver forms to 60% of the people who walk in the Metropolitan County Courthouse trying to get a divorce who don't have lawyers? Over half.
And that is an issue, but again, if whatever they're doing now, it is or is not the unlicensed practice under current laws and rules. And this doesn't change that. But if a person is harmed, then they would have a separate right of action for that.
Are there no state bar opinions that the...
There's a lot of opinions, unofficial and official opinions, dealing with areas of practice as well as Supreme Court.
But forms of nonprofit versus for-profit entities, is there any...
I'm unaware of any distinction in the case law.
I think the holding it out as being an expression by them that this meets the Georgia law requirements is expressing opinion as to this, as useful as might be. That's what I'm trying to think of, is they generally have something that says, is our opinion this meets the requirements of Georgia law. Correct?
I'm sorry, I lost the
looking
question.
at the LegalZoom. I've been a long time since I looked at the site, but I've heard that they have this meets the legal requirements of Georgia law as an expression.
Instead of a disclaimer that says we don't know anything about anything, good luck if you use our form.
I think so. So it's a question whether it gets to the level of being considered the unauthorized practice of law because it's expressing that opinion. Mr. Welch, you're next, and then we'll have this.
Thank you, Mr. Chairman. To the person testifying, I forgot your name. Sorry.
John Taylor.
Mr. Taylor. Mr. Taylor, the question I have deals with the language in the bill that says violation of the Supreme Court's rules or opinions. Are the opinion, when we're talking about these are opinions issued by the Supreme Court with respect to those, and those are generally regarded as enforceable with the state bar, is that correct?
Correct. And if I might expand on this just a moment, there's this ongoing tension, for lack of a better word, between the legislative definition of what's the practice of law and then the Supreme Court seeing it as within its purview as being the definition. So to fully cover the universe of what it means to be practicing law, we felt it necessary to include both, of course, the statutory provision this refers to, as well as the, matter of fact, for example, there's an opinion pending before the Supreme Court right now on the what constitutes the practice of law, the unlicensed practice within, within a real estate transaction. So,
Ms. Stevenson.
Thank you, Mr. Chair. Attorney Welch asked my first question. The second is not the material difference between the legal Zoom and what my colleague asked regarding the family law. You have to sign the waivers, and they provide you the forms. My understanding of legal Zoom is that they prepare the information and send you a complete package.
I'm not familiar with their process.
They prepare the forms. You cannot just, they don't just provide you with forms to complete. They complete powers of attorney's wills, and then they send it to you. So to me, that's materially different than the application of the forms and then having someone maybe assist you. And I think that's
so if they do that and someone's damaged by it, there potentially could arise a cause of action for that failure to properly prepare the documents or give the right information. Okay. Any further questions? If not, anyone else wish to address the committee? Mr.
Yes,
Sewell?
Mr. Chairman, it's all right. My name is Rusty Sewell, and I represent the State Bar. I appreciate, and I think it's been a very good discussion. Let me make sure and I understand. We're not saying whether legal Zoom is practicing law or not practicing law, or whether anybody else. This whole purpose of this thing is an adjunct to 2 years ago. The real estate section had a bill, if y'all might remember going through, that dealt with it. It's been a big problem, particularly on closings and other things involved. Yes, sir.
Witness closings.
And so this is a wide range. There are a lot of people that do forms or whatever. We're not trying to say whether somebody is practicing law or doesn't practice law, and we wholeheartedly support people doing forms that making them out there and are saying from all the different groups, and that's fine. All this is just so some individuals, these things can't really be prosecuted, and it's just allow somebody, if they are damaged, and they've got to be damaged, then they can have something to do.
Thank you, Mr. Sewell. Ms. Taylor, too, thank you. Any other wish to comment to the committee? If not, the chair will close all further public input. The bill is now in the breast of the committee. The chair will entertain motion. Move to pass and second it. Any discussion on the motion? Any amendments? Not, the chair will call the main question, which is motion to pass House Bill 889, which is 5900S. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. That concludes the business for the day.